Good afternoon, everybody. Welcome to the New Jersey Bankruptcy Podcast. We are powered by the law firm of Straffi and Straffi, and I'm your host, Daniel Straffi Jr. Today, we are welcoming our guest, Mr. Jeffrey Horn. Jeff is a member owner of Horn Law Group located in Toms River, New Jersey, a longtime friend and a practitioner of family law for well over 30 years. Jeff, welcome. How are you today?
I'm great, Dan. Thanks so much for having me. It's my pleasure to come on with you. No reason for me to be nervous. We've spoken many times, but I guess it's excitement nervous.
That's what it is, especially from the technological standpoint of actually making all of this work. But when I thought of my first guest, I could think of no one other than you with your previous history podcasting. What's the status of that, Jeff? Are we still doing it or what?
I did the bold sidebar for a few years with a couple different formats, and then I just got overwhelmed with a bunch of other fun stuff, practicing all of them. And then I've run for office a couple of times and helped a lot of other candidates. So all of a sudden, I just didn't have time. But you're definitely motivated me to get back to it. I got to say, I'm excited to help you out. You helped me out. I'm looking forward to doing this. And this is like the conversation we've had many times.
Exactly. For the benefit of the greater public, we're going to talk about bankruptcy in a certain respect as far as how it interrelates with divorce. And we see it happen all the time. I guess that gets to my first question for you, Jeff. What happens if one spouse finds out that the other spouse has secretly racked up some form of debt? Have you experienced that? I'm sure you have many times, but what is the first reaction that you have when you encounter something along those lines?
The first reaction is always, I feel bad for that person, and I assume they're being sincere with me. It really is a blow if people think they've got a pile of assets that is not offset by a bunch of debts, then they find, whether it's credit card debts, or I've had people even with mortgages, they either forgot that they racked up another mortgage or they forgot about some of the debts. It can be very devastating. I've studied the statutes and the case law, and I've tried to find the thing in those that says, if you don't know about it, you're not going to be on the hook for it. But that's not where we start in New Jersey equitable distribution law.
100%. You've been very generous in your bankruptcy referrals to me, but have you found the interplay with bankruptcy to be helpful as far as advising clients in that regard?
Yeah, I mean, you're the one who taught me about this following statement. It's been in my head for years. Every bankruptcy client that walks in has a sincere desire to pay their bill. Maybe there's the rare outlier that's kind of a crooked guy or gal. And same in their divorce. They want to get rid of their debts, divide their assets, be fair to their children. That's what everybody wants to do. I always thought bankruptcy was a super scary thing. If you're bankrupt, it's like not only are you bankrupt because you don't have money to pay your bills, you're morally bankrupt. You're bad. I think bankruptcy has saved a lot of people's divorces from being horrendous when it just became manageable. Now, it's hard for them to bite off a divorce in a bankruptcy all at the same time. I found in a number of cases, especially when we came out of the great financial crisis 2008 and for a number of years thereafter, the bankruptcy actually helped people get that fresh start, which divorce can do it too if you have the right mindset. And you can't get divorced to get a fresh start and have enormous amount of creditors chasing after you.
Yeah, so much of it is dispelling that stigma. You know, there used to be the stigma associated with divorce. Unfortunately, it's so prevalent today. The majority of marriages end in divorce. But when it comes to the bankruptcy stigma, it runs the gamut as far as all classes, income levels, ages, you name it. And the majority of people do want to try to pay their debts at the end of the day. But it's very difficult to get by in New Jersey these days. And if someone's secretly racking up debt, I mean, forget about it.
Yeah, it's really tough. And maybe going back earlier in my career, I used to think, oh, these bad people secretly racking up a debt and their spouse doesn't know about it. And then I go, they probably were trying to not alarm their spouse. Well, I'll have this debt move over here and I'll move it over there and things will get better and I'll wipe it all out and then we'll be back to equilibrium and then it doesn't work out and then marriage has hard times and financial hard times. So it's like a combination.
That's a great point because the question I posed kind of assumed that someone was doing something nefarious. That is not necessarily the case in many of these scenarios. Oftentimes, it's someone trying to protect the other spouse. They should have communicated, but it doesn't always happen, as we know. When you're trying your best, you're robbing Peter to pay Paul, you're getting balance transfers, you're doing whatever it takes in order to get by. It can get away from you rather fast.
No one sees it going how it ends up, right? They go, okay, I'll kind of hide this bad decision I made or this mistake I made. And then you compound it. Look, there's gambling, and there's all kinds of reasons that it might get started. It's like in politics, it's always the cover up, not the underlying crime that's so bad.
Indeed. Now, Jeff, you say that fear can often paralyze people during a divorce. How do you help clients move from that panic to ultimately planning?
That's really important for people. And it's the old adage, how do you eat an elephant? One bite at a time, one slice at a time. Their fear is one giant ball, and they don't know how to slice it up or break it down. So that's the first thing we do. Just get things into smaller chunks. If you chunk it down, things become a little more manageable. And for people that are really gripped, I learned this technique years ago. I believe Tim Ferriss, another big podcaster, spread it effectively, called fear setting. And you just go, okay, what's the scariest thing that can happen with your credit card debt? Oh, I can't pay it and I can't use my credit cards. Okay, is that the worst thing in the world? Well, it's pretty bad. Make it worse. And you let people break it down to the most scary possible thing that can happen. And then they go, that's probably not going to happen. And it
Mhm.
kind of takes away the grip of the fear. The issue is still there, but it's kind of the grip and how you handle your plan going forward. As you say, you go from scary in the grip of the fear to a plan, to a strategy, to, I'm an agent of the future. My job is to
Mhm.
get you through today with the hope that you're going to create the future you want post separation, post divorce, and hopefully post this kind of fear.
And the whole point of a bankruptcy at the end of the day is to get a fresh start. And in many ways, you are the arbiter in the divorce, trying to get your client to that fresh start. They have consistent values in that regard, consistent goals. Part of what we're taking from today is your book called Shockproof Divorce. Where'd you come up with that title? And how did you come about in crafting that?
This is from the first days of my practice. I was a note taker. So I would just start scratching notes. It took me a few years to go, man, people are really shocked by almost every bit of the process, from paperwork we ask them to fill out to what happens on the first day. And I go, okay, how can we help folks out? Well, make them shock proof. So they have a little shock absorber in between their current thinking as someone who's not gone through this process. I mean, very few people go through the divorce process so many times that it's old hat to them. That's
Not
a
that we don't see repeat
we
customers every
do.
now
We
and then.
do. We do hundreds or thousands over our career. Two or three is one sample size. So that's kind of how I came up with that. And I always joke, I had one child in early in my practice, and then I said, "Oh, I'm going to write a lot of books." Second child came, and well, I was about that. Life took over. But I always thought people, again, they were shocked by the process. So I thought they got very angry about the process. So one of my kind of little principles I've shared in there is avoid the process anger, defeat the process anger. Don't get mad about having to fill out the form, or don't get mad that your spouse didn't fill out the form correct. Let that just be one piece of this entire puzzle. And the other thing is, a lawyer hears from a client, fight it to the death. Take it to the
Mhm.
Supreme Court. I don't care how much it costs. Okay, great. We get all excited. We want to do cases and apply our trade in the most competitive environments, whether that be the New Jersey Supreme Court. And really, that's not what they needed. They needed to go, well, you want to get money from your equitable distribution or alimony. So how much do you want to spend to get how much? So I always look at this like net dollars. What's the net dollars? If we do this motion or file that appeal, what are we going to spend? What can we get? So that net dollar analysis was always something I thought would be really helpful for people to measure out their litigation spend in dollars as well as time and energy.
And that pragmatic approach to it is really, I think, the crux of trying to allow folks to get to the end of a divorce without having to necessarily go broke or end up in a bankruptcy. I mean, our trades can be very complementary in that respect, but is that how you try and approach things overall?
I consider it a failure if we're working through a divorce case and the other lawyer is reasonable and the folks have to go bankrupt because of the case. Either party, whether it's my client or the other client, look, there are circumstances there that's going to happen. We know that's going to happen. It's just what the parties came to us with. But for us as lawyers, we ought not to exacerbate someone's financial hardship with the case itself if we could avoid it.
Right. And I think that emotion can play such an integral part in the decisions that are made during the course of it. We as attorneys have to maintain our cool, keep that objectiveness. Do you have any stories of where anger may have influenced either the client or counsel on the other side to where something goes downhill? And what did you do in order to try to rehabilitate it for the benefit of the client?
That story is in here almost every day, unfortunately. I can't say I'm immune from getting competitive and wanting to litigate a case to a certain result and do what's right in our assessment. I can't say I've never been the one to go, oh, let's just go and litigate this issue hard and we'll come out the other side and find out, oh boy, that was not worth it. I am wrapping a case where the parties really had a lot of anger, mistrust. There was double temporary restraining orders.
Mhm.
And we had multiple days of court and witnesses. They both could have gotten a final restraining order against one another. And then they woke up and said, whoa, we're separated now. That's permanent. We're going to raise our children. And they spent a ton of money for really no gain. And I didn't realize it. I have to be honest. The other side didn't realize it. We were just doing our job. We were soldiers litigating a case, Dan. And we kind of woke up to it earlier and said, hey, guys, but they weren't ready. One of the funny things about family court is things don't happen in consecutive days. So
Right.
this I'm talking to you about happened over a lengthy period of time. And the gap time was what saved these folks from themselves.
So you had trial dates several months down the road from each other,
Exactly
basically.
right. I visited my daughter was in a semester abroad. So that put me out of commission for a few weeks and the judge was on fire about it. The other side was on fire about it during that time frame. The parties, when they were doing their parenting exchange and so forth, they got the light bulb that said, what are we doing? We've had days of trial and we're
Mhm.
still going to have to be dropping the kids off to one another. We're still going to have to deal with our house and our bills and our incomes. And they kind of said, okay, let's move on. And that's just a recent example. These people burned up tens of thousands of dollars that if they just didn't have that emotional impetus, that would still be in their pocket. The worst part about this job sometimes is when, let's just say, three of the four folks involved, both lawyers and one of the clients, figure out, okay, here's a good landing zone for these guys. Okay. And the other side is just gripped in that anger
Yeah.
and they can't accept it. And then you start to litigate a case, and all of a sudden it's going bad for that person. And actually, the result they're going to get is worse than the negotiated settlement. So we've got a worse settlement for the person, and you've now spent a ton more money. I'm not rooting for that for anybody. And that's the result of not being circumspect about what the case is about. And no matter of anger, no matter litigation capability, right? A lot of lawyers are really good at litigating, but that's a capability that should be utilized sparingly, and especially in a matrimonial case.
Well, it's like preparing for war in order to get where you really need to go. But some people want to push the agenda in that regard. How do you keep that big picture focus for clients? Because you have to do your job at the end of the day still, too.
Yeah, not too long ago, had a client who came in guns blazing, paid us a good chunk of money, and we started going down the road. I guess if I get in trouble with clients, Dan, it's because I tell them how it is maybe too often or too bluntly. I'll plead guilty to that.
That's part of the gig, though. That's a credit to you.
Well, I appreciate it, but it doesn't pay every day. I sent the guy an email that says, here's what I see now. And I can't see justifying spending a lot more money on the case. And it didn't go that great. The guy was really mad at me. And we have this fee arbitration process. So he took me to fee arbitration. And I just said, look, I didn't want to spend what we spent. In fact, I gave the guy a nice discount at the end. The arbitration panel says, sir, he did more work than he billed you for. So what you paid is what you paid. I felt bad for that guy, but he couldn't see, even in black and white, what the people on the panel saw. Like, hey, Horn said to you, don't do this because it's going to
Right.
be hard to see a victory in terms of dollars and cents. So that does happen. But I think that's increasingly rare, Dan, because it costs so much to litigate. So even the well-off folks go, this is a questionable spend use of my dollars.
Well, especially in a trial context with the amount of litigation funds that judges are inclined to give to attorneys, which are necessary, mind you. But we're talking about tens of thousands of dollars up front before a trial and the years that go by before we even get to that point. as far as attorney's fees are concerned. It's tough to keep all of that in context for folks when they're in the middle of it.
100% right. I try to say to people, I want to be one of your greatest investments in your life. I want to be like a 10 to 1 investment. So every dollar you spend on me, I want you to get 10 back. That's the goal. Those that have that mindset do tend to use our services consistent with their goals and not consistent with their fire and their belly or anger or disappointment, or
Hmm.
they're cheerleaders. They're people that are in their ear and they make decisions based upon maybe not their own best interests.
Now, when we get into the issues associated with a divorce, I think overall it's rather common knowledge that domestic support obligations like child support and alimony are non dischargeable in a bankruptcy. Do you find that clients have a general understanding of that, or is that something that you talk about? Do you talk about bankruptcy issues at all in your
Yeah.
consultations?
Well, if it's on the radar, for sure, some of the details of bankruptcy that I've got a grasp on, I wouldn't say a grip, but a grasp, are
Mhm.
tough for people to follow when they come in and maybe they've got this pile of debt and they're looking at a divorce and a chapter 13 at the same time, and what can be rolled in and what can't be rolled in and the fine points. I don't try to pretend to know all the fine points. I tell them assume support obligations, including counsel fees that were ordered, are not going to be so easy to get rid of. Equitable distribution, if you're talking post divorce, assuming you're not getting rid of any of those obligations to your spouse. That's what I
Right.
generally tell them. I say, call the experts. Don't count on what I'm telling you. Even if you're snapping back to a couple of cases I had, particularly when things were rough in the economy and people had developed properties and they had a lot of debts. We're talking
Mhm.
big debts, like millions, and now there's divorce. Don't count on the family court and having a deep understanding of what's happened in bankruptcy court. So kind of like get clean in one area and
Mhm.
clean in the other at the same time. Don't try to cross pollinate those problems to confuse one judge in the other realm, because my suspicion is they know the tricks.
I think that's a fair statement overall. And there's a lot of deference given to what takes place in the underlying state court with the divorce in the bankruptcy realm. So you can't take that for granted that bankruptcy will be a cure all or you'll get a second bite at the apple.
That's my sense. And I think people sometimes will come with the idea that it would be easy to get rid of a family court obligation in bankruptcy court. And my words are always cautionary rather than encouraging off the bat.
Now, in negotiating a settlement or making an offer, do you keep bankruptcy principles in mind as far as trying to get more into an alimony award than on an ED side of things? Or does that ever come into play?
Really does. And right now, I have a case in particular that's teetering. There's complexity, there's a forensic accountant involved. I could see a bankruptcy actually simplifying the divorce. There's a pile of debts that nobody wants people saying, oh, it's secret debts. Everyone's pointing at the other person, but these are not like a credit card or a cash advance. These are much bigger debts that they're
Mhm.
each pointing to one another. And I almost go, well, if we got these debts managed into a chapter 13, okay, here's the payment, and now someone's got to make the payment, it would crunch down a lot of the arguments about what is there and what's not there. What should we put into a support piece? What should we put into an equitable distribution piece? In that particular case, it could be really creative. The folks right now are in such a place of mistrust that I don't think they're going to cooperate. But if they did cooperate, they'd really manage the debts and they both have more money in their pocket.
Is it more in a business context, like as far as
Correct.
tax obligations, SBA loans, things of that nature?
100%.
Yeah.
Business debts, personal debts that are tied to the business, SBA loans that are not being paid for 5 years, a ton of tax debt, multiple businesses. And it's not a bankruptcy because the parties don't earn money. They
Yeah.
earn a lot of money. And yet there's these debts, and then the pointing, blaming, etc., that's stopping them from just taking a deep breath, cooperating, managing these debts. I mean, they're going to pay off a lot of their debts. Even in bankruptcy, imagine they would pay off a lot of their debts because they have substantial income. But everyone would have more cash in their pocket this month, and they would have the ghost of the creditor that's chasing them, or creditors that are chasing them, they can put those ghosts to bed and sleep at night.
I always tell clients 50% of what we do is provide relief from financial distress. The other 50% is that relief from emotional, mental distress that inevitably leads to physical distress because you're not sleeping, your health is becoming poor. You've made mention of Chapter 13, which we know is a reorganization. Sometimes just getting that respite from your creditors and being able to extrapolate that debt out over a period of 3 to 5 years, interest free. When you have people who have the income to do it, that break can mean a lot, especially with the nature of interest rates these days.
I hope these two folks, one is my client and one's not my client, hear your words and echoes through their mind. And I think they really could benefit from it. That's a case that's on my mind. It seems like bankruptcy is maybe going up a little bit right now, and uncertainty is out there in the marketplace. And like you said, the interest rates have gone up tremendously the past couple of years. I expect to have more. And I cheated because I knew I had to do this. So I did a little lookup. And if you look at the bar chart, bankruptcies went
Hmm.
down a period of time. And I did a divorce thing. They went down a period of time. And they're both going up right now.
Yeah.
I think
Yeah.
volatility contributes to filings in both realms.
I would absolutely agree with that. They're so interrelated. We know that financial distress can often lead to the breakdown of a marriage. People hide things, their communication lessens. It provides that rift. Now, if one spouse ultimately files bankruptcy during a divorce, how do you handle that? Are you the first to know? Are you the last to know whether if it's your client or not? How do you find out and then what do you do from there?
It's a great question. If it's my client, I hope I'm among the first to know. I have a good relationship with the client. We're going to be working together on that. If I know my client is looking at bankruptcy, I'm going to try to get my client's consent to communicate with the other lawyer and
Mhm.
share with them this is part of a strategy, and we want you guys to at least consider joining in this strategy. And those that do, I think, are those that get the best financial result. And as you're saying, get that good night's sleep, get that monkey off their back. But sometimes they won't talk and they won't even have it. And then they get the lawyers. I've had lawyers get mad at me when I say, hey, just so you know, client X is looking at bankruptcy, consulted with a bankruptcy lawyer. So back to your question, I'm going to let the lawyer know. Let's assume I know. Okay. But the way you find out is all of a sudden you just get a notification from the bankruptcy court that you're on a list of creditors. That's a pretty harrowing way to find out what's going on in a case. No one likes that. But I've had that happen. I've had my own clients, not that often, but more often
Right.
someone else. It's like tangential to the case, but we're just like a party that's being notified of a bankruptcy. We're on some list of creditors where even if we're not owed money per se, but it's something we're going to be provided notice with. And then the next part, I think you started to allude to this, it is like a smoke bomb in the family court. So
Mhm.
family court finds out, and our courts here, I got to say, they are wonderful, efficient. They do absolutely the best to move these folks from A to Z in an efficient way. But that's a curveball. They see it, but somehow it's never the same exact procedure every single time. You're a sports fan. Is it like injured reserve? Is it like the commissioner's reserve list? We're just put to the side. Does the family court continue to manage the case and just bring us back every 60, 90 days to go, where are we with the bankruptcy?
Does
No.
it go totally to the inactive list, never to be found again?
I've had the 5-year-old case because both parties went bankrupt at different times and just nothing happened. Oftentimes, when folks are going bankrupt in their divorce, they're not paying their lawyers. So now the lawyer
Right.
back burners it or gets out of the case. And the parties, they're not represented. The lawyers are gone. So no one
Yeah.
knows how to restart it. There is an abyss that some bankruptcy filings create. You have to be a jack of all trades in so many ways. You've got to know
So true.
enough about bankruptcy. You've got to have a working knowledge of the nomenclature, automatic stay, what's stayed, what's not stayed, what you can handle, what you can't handle, that relief can be granted from an automatic stay. You have to know those basics, I would think. Maybe a couple of more things too, but
Yeah.
those basics, it does tend to put cases in a different loop than the regular divorce case.
I really liked your answer about reaching out to the other side when you're contemplating it in the first place. Do you find yourself when you're trying to strategize an approach with a divorce with your client, trying to speak with the other side about whether or not it's appropriate to file before a divorce or after a divorce? What comes into play in your communication with both your client as well as perhaps opposing counsel?
Yeah, so let's just assume for the moment that no one's filed for divorce and now we're gathering the information needed, what we call in family court the case information statement. It's kind of the same in bankruptcy. It's kind of the same info is going to be needed. All of a sudden, you see this pile of debt, and these debts, which are going to be paid, which are going to be forgiven, which is like something that might go away by its own weight. But not the IRS, not the SBA, not the mortgage company, not the car loan. Maybe your aunt's loan, who loaned you so long ago to buy a house, is willing to let that go. We have to make that judgment call early on. But if there's a pile of debts, and as I say, I only find the pile of debt in the beginning of the case, a case where there's a lot of income. Because a lot of times folks
Mhm.
that have already, maybe they didn't have such high income and they got in some trouble with some consumer debts, they might already have gone through bankruptcy. That's not uncommon. They say, oh, we did bankruptcy 2 years ago. So now they're not in bad shape with debts. But the folks who come to me are always with a bit of a complex financial picture on top of the debt. Look, I'm the first guy to go, my job would be really easy if instead of a huge pile of debts we can pay, it was $1,000 a month payment to the
Takes
thousand
a
a month
lot
payment.
off your plate.
And even if it's $2,000 a month, I can manage that with income. But when I don't know what it is, and it's going up every month, the IRS, and its interest, and its penalties, and no one has a statement for the past 2 years, they throw them in the garbage. It was
Yes.
60,000, now it's 85,000. Those are the things where I just want to go, okay, if we know all the facts, let's get a consult. Let's get one bankruptcy lawyer, not
Right.
two different ones. That's when people really are suffering the horrors of mistrust when they go, I can't even trust the bankruptcy lawyer who doesn't know either one of you guys. So
Yeah.
they don't care. They don't have a bias. I mean, I'm biased for my clients. I want them to get their best deal. But from the bankruptcy lawyer, no, bankruptcy lawyer is not going to say, oh, I'm for this person because that person did this or that. They just want to get them
Right.
through the process and get them to that reasonable payment that manages that huge pile of debt that turns into a free loan for 5 years. Who wouldn't want that if you're in trouble?
Exactly. And is there a certain point in your analysis of a case, whether it be before the divorce complaint is filed or more commonly during the discovery process, where you are seeking out a professional aside from yourself, whether it be an accountant, a bankruptcy attorney, to kind of provide your client with guidance?
In accounting world, they talk about fair market value, which starts with the premise that both sides have equal perfect information about the transaction. Well, I never have perfect information at the beginning of the case. It's almost in the breach that I know everything I need to know in the beginning. And my client has a good sense of where the other party wants to go. Let's assume we have this whole thing. We've got businesses, we've got debts. Do you know what you guys want to do with this building or you want to do with that business? People don't know. So my experience is they don't know what they don't know. So you start going through the process, and I can't do another thing unless you tell me where we are with the potential for bankruptcy. I can't do another thing unless I have an evaluation of a piece of land or a piece of property. I can't help further without that data point. The court's breathing down their neck. It has to be sometimes for decision making. Then people will make the decision. We know that about our species. We tend to be more reactionary to pain than we are to good decisions when we're under stress.
Well, I think also when we are under that stress or we feel it out there, even if we're not addressing it directly, we tend to dig our head in the sand and wait for it all to come up at once and address it all at once. And sometimes it does take an accountant to dig into things from a fact finding perspective before you're going to have everything that you need to make those informed decisions. Now, divorce at the end of the day often means splitting one household into two. How do people from your end handle the financial pressure of that change? And what do you do to help guide them through that process?
Yeah, I mean, if I was in charge of the world, I would go back to one thing that we enjoyed in the early 2020s was these low interest rates. Because my job, when people could just go and get a 2% or 3% rate and they could separate into two and both parties' mortgage payments is like comparable to what they had when they had a
It was a
6%.
catch-all.
It was manna from heaven for us. Then it went from
It was a
2% and something
catch-all.
to 7% suddenly. It's a couple of years since that happened, since interest rates zoomed up. But we're still suffering because if someone comes in and they've got a bunch of equity in the house, but their spouse is on the debt, and the spouse goes, you can keep the house or we'll make a deal, but I want off that mortgage. And that person has to call up the bank and go, I need to refinance 500 grand. And they go, okay, great. Your mortgage payment's double. They faint immediately. And I get that. It's a big deal. What I have people do, rather than try to get them to make all the decisions at once, is go, okay, let's work through it. If you stayed, what does it look like? What's the dollars and cents? I can run an amortization for them on the computer so easy now. And if you're going to move, people come in, right? They go, I have to stay in the same school sending district because my child has 3 more years of school, something like that. Okay, let me know where that looks. What does it look like? What's the availability of houses where you could go from house A, that go from the big house to two house Bs, right? Can both of you guys stay in the sending district? Is it
Mhm.
possible? That's the dream scenario. It's been much tougher. Rents the past few years went through the roof. Interest rates went through the roof. I just try to boil that down to dollars and cents. Some folks have some surplus funds where they can take money out of an investment and use that as the cushion to get through these 3 years, hypothetically, and keep them in the house, or pay that increased mortgage that's going to pop up with the new interest rate.
And I mean, what would once be, like you said, an easy buyout scenario because money was so accessible at a lower interest rate, I would imagine that now you have to be a bit more creative in trying to help folks keep their marital residence. Does debt come into play in that regard as far as
Oh,
an
yeah.
assumption of debt on one side?
Yes, absolutely. I just had this scenario. The cases with businesses or people that have a lot of assets, but they also have a lot of debt. Those are the ones where you have more to lose, but also more creativity. One case we just did, the folks have done something that I don't love, but they've done it. They hung on to marital home, debt in both parties' names, huge pile of other debts, business and related. One party took all of those debts on. And the idea was exactly what we're talking about: get their
Yeah.
child to the end of high school, and then someone can buy out,
Then
someone
we'll
can
deal with the
sell.
house. Yeah.
And one person, I got to give this person a lot of credit. They really put their nose to the grindstone and got rid of those nasty debts that had arisen during the marriage. They both managed to make these payments, and now they got to the end of the road for high school. And then they can make a decision now, and they're in the middle of that right now, i.e., someone buy out, and the debts are gone. The other debts are gone. Like, they've really done a good
Yeah.
job, or sell and have an allocation of the proceeds after sale. They can make a decision, but that's really a high level of cooperation that I encourage folks to embrace.
To try to undertake at least, and punting the issue of the marital home. Not that you're not addressing that credit presently, but to give yourself an opportunity maybe for interest rates to lower, to give yourself more opportunities. All of that has to come into play. And the fact that you look at things creatively and thinking outside the box is so important to your client.
Well, I appreciate that. And of course, we've put you to work many times as the mediator. I go, oh, you have
Yeah.
a lot of debts and you're getting divorced, and I have the guy. He can help us navigate what to do with debts. He can talk about divorce. That kind of puts you in the crosshairs of a lot of business where people have to manage both at the same time.
But it speaks to the fact that divorce today, it really requires a comprehensive approach. There's just too much at stake across the board. We need, in most scenarios, two incomes to maintain a household. And when you're accustomed to a certain lifestyle, and now we have two different households trying to make it, it requires a level of detail and strategy and thinking outside of the box to really make it work for people so that they can get that fresh start.
Sort of teenage children, and now here comes car
Right.
insurance, and those expenses around the corner. And then you've invested some money in college. That's how I look at it. I don't know when the payoff
I like the
comes.
word invest. That makes
Uh,
me feel better already.
there'll be a payoff, but here comes another demand on your cash that you have on hand, or new debt with payments that, unless I'm slow on this, pretty hard to get rid of: student loans, parent loans in bankruptcy court.
It is, and I have had a tremendous uptick in people seeking student loan consultations because of the new administration. They are making it a point to collect more aggressively, whereas the prior administration was looking to forgive or defer. So all of that is coming to a head. It will require ongoing creative solutions because some of these student loan payments are like mortgages. So now, in the cases where you have had divorce and bankruptcy collide, is there some kind of tried and true rule or approach that you've taken from it that you can say, generally speaking, you need X, Y, or Z when those sorts of intersections occur?
As I was saying, you've got to have a tool belt with two sides of it. One is the tool belt of understanding there's an automatic stay, what's going to be in, what's going to be out, that the divorce doesn't have to stop. It doesn't have to be totally mothballed. just certain things will be stayed. Enforcement might be stayed on some things. It doesn't mean you can't work on the other technical pieces of it. And then the other side is if it's one party filing, the non-filing party almost always sees red. It's another betrayal. It's another mistrust. It's another thing to get really upset about. And that's our biggest job, I think, is just to bring that person back and say, yeah, this might cost us a few months. We might be in no man's land for a short time. And yeah, there might not be enforcement. There might be a couple of things that's going to derail us. Or maybe the bankruptcy court's going to have to do something kind of drastic, i.e. sell an asset, right? Because it's just what they've got to do. The trustees just got to do that. Now, that's going to take more time. Just try to let them know and give them a kind of a roadmap. We all feel a blow if there's an unexpected bankruptcy filing in the divorce case. Don't do that to me. Let me know. I'll try to do the same and see if it makes sense for my client to join, right? The times when one party filed, let's say maybe it happened 30 times. I bet you 20 of those times the parties would have benefited from working together. Maybe 25 times they would
Some
have
type of
benefited.
joint filing.
A joint plan, whether
Yeah.
it's filing or not filing, they would have benefited from not doing something that they thought was going to only advantage one
Yeah.
side versus the other.
A cohesive strategy, regardless of whether you decide to file jointly. Let's all be on the same page as far as approach is concerned.
There's no question that would have saved parties grief and likely professional fees as well.
Yeah. And I like what you said at the beginning of your answer. Just because a court puts a case on an inactive list as a result of a bankruptcy filing doesn't mean that the parties have to be inactive. You can still work amongst yourself to try to get to an end with your divorce. There's plenty to discuss, that's for sure. We're kind of have a couple of questions that rely upon your overall experience and wisdom. If there is one thing that you could change in the law to better support divorcing couples dealing with overwhelming debt scenario, what would that be?
I like that. You put me in charge of the world. I don't think my kids would appreciate you. They already say, Dad, you think you know everything. I always joke, for people that know everything, meeting a know-it-all is the worst thing in the world. I find that we ought to have written somewhere in very clear language that debts are not bad, number one. Number two, saying that you don't know about a debt, a secret debt, is okay for shaping your thinking and explaining why you're mistrustful of the other party, but it's still a debt. And number three, my cases, and I counted them up, and it's thousands of cases in family court over the years. In all my cases, I've found 0 times where a party took a position that a marital debt was not something they were willing to address in a settlement or an equitable distribution, where at the end of the day, it saved them money taking that position. They might
Yeah.
have not paid that bill or another bill, but the cost in professional fees and in dragging the case out caused them on a net dollar basis to have less dollars in their pocket at the end. I'm pretty
Right.
sure that's 100% true. And people can get mad at this and go, well, what if my spouse spent $2,000 on a vacation to be
That's an obvious one. We could
to be
point
out?
to that one.
I'll give you
Right.
that. I'll give you sending flowers to a love interest. But if you go, okay, let's spend a lot of time and money and accountant and lawyer time. You want your lawyer to review every credit card statement and bank statement for the past 5 years, and you get a huge bill, which maybe wasn't the best judgment all the time for the spouse. But at the end of the day, we're not going to say that's not subject to equitable distribution. I would want that warning to be like a cigarette box warning. Warning. Fighting over every dollar of debt in equitable distribution will cost you money. That's what I want. Put that warning label on divorce.
Dissipation of assets is the heading for so many grievances for folks. And it can be a slippery slope as far as investment in trying to prove that.
It's got to be a lot of money, and you got to be able to prove it inexpensively.
100%. Any final words of wisdom for our listeners who
Well,
may be considering a divorce, Mr. Horn?
Well, two different kind of listeners. Our listeners that might be other lawyers are going to be mad at us right now because we just said, hey, clients out there, potential clients, don't do all these dumb things that give lawyers a lot of money for doing nothing. So, all my lawyer friends, sorry, not sorry. For everyone else, if you put your cards on the table kind of right away and you find out you've got a lot of debts, don't go, oh, I feel guilty. I'm blaming my spouse, myself, my mother-in-law. Don't do any of that stuff. Consult with your divorce lawyer, your accountant, and get your lawyer to contact the other divorce lawyer and say, let's have these folks talk to a bankruptcy lawyer. Most of them charge maybe nothing or a tiny amount to just review the picture. And I find that the bankruptcy lawyers are very clear in their analysis. They go, okay, you're a good candidate, you're a bad candidate. And then, because you have a tentacle in both of these areas, you have that ability to go, I can absorb that emotional piece. Some of our bankruptcy colleagues are more mathematician kind of guys, more science guys. You need art and science here to
Yeah.
handle folks that are upset because their marriage is failing. And also, they've got to deal with debts, but they're not the same.
100%. It requires a balancing on both ends without question because of that emotional component. Thank you so much for all of your time here, Jeff. How about a plug? Tell us what's going on with you personally. You always have your hands in a variety of things. Tell us about Horn Law Group, what you
Yeah.
guys are up to.
Well, first of all, it's crazy that we're talking because we've spoken so many times, and all of a sudden, it's like an hour. We've been at this for a long time now. It's my pleasure. My friend's like, "You're still working?" I'm like, "What? I'm going to keep working as long as I can." My daughter, she's a college senior, and she goes, "Dad, do you do something different every single day?" I really do. I work on the second floor. So I come up the steps and I never think of going back down and saying, forget this, I'm going home. So we blog a lot. We put a lot of
Mhm.
on our website and working on more stuff now. I'm working on a journal I would make available to the world for people to work through some of these questions that are bugging them. We're literally working on that today, myself and Dylan, who's our summer intern. He wants to be a lawyer someday. So it's always on my mind and how to make this a little bit easier for people. And that's another tool. Feel free if people want to check out the Horn Law Group, hornlawgroup.net. Dan, a pleasure again.
Thank you so much, Jeff. And thanks everyone for listening. Have a good day.